Imagine the scene. It's Havana, June 1960. It's 2 o'clock in the morning, 2 in the morning. The air is heavy. It's humid, that, typical Caribbean summer heat that just sticks to your skin. And you're standing in this massive crowd listening to Fidel Castro. And if you know anything about Castro's speeches from back then, this isn't some tight 15-minute press conference. You're in for the long haul.
Oh, absolutely. This is a marathon. He's in the middle of a 3.5-hour speech. He's railing against the United States. His voice is echoing across the plaza.
Right.
And right in the middle of this tirade, he drops a line that basically sets the stage for a 65-year legal brawl.
He declares that he's going to seize Yankee property in Cuba, but he adds this incredibly vivid, almost petty detail. He says he's going to take it down to the nails in their shoes.
It's such a chilling phrase, down to the nails in their shoes. I mean, it implies a total stripping of assets, leaving absolutely nothing. And the thing is, looking at the history books, he wasn't being metaphorical.
No, he meant it. He meant it literally.
He absolutely did. That really brings us to the mission of today's deep dive. We're looking at a stack of legal documents, Supreme Court briefs, historical records, all revolving around a huge case. Exxon Mobil versus Cimex SA.
Quick reminder, please follow, rate, subscribe, share, and review the podcast on Apple, Spotify, YouTube, anywhere you podcast. Follow on LinkedIn to read written rundowns. Just search the High Court Report. Because unlike Cuban property law, subscribing to podcasts actually works the way it should. Questions about this case? Reach out to us via LinkedIn at the High Court Report.
All right, here's what you need to know. Exxon wants to sue the Cuban government for trafficking in their stolen property. Sounds straightforward, right? Plot twist. The Cuban companies say, you can't sue us. We're part of a foreign government, so we get immunity.
Wait, foreign governments get automatic immunity in U.S. courts?
Not automatic, but there's a whole law called the Foreign Sovereign Immunities Act that makes it really hard. And here's the kicker. This case could determine whether Congress can override that law when they really want to punish a specific country.
And we're not just talking about one lawsuit. We're talking about whether any American whose property got stolen by Cuba can actually get their day in court after waiting 65 years.
The formal legal question, and I'm going to need you to make this sound more interesting than it looks on paper.
Challenge accepted.
Whether Title III of the Cuban Liberty and Democratic Solidarity Act abrogates the Foreign Sovereign Immunities Act and allows lawsuits against Cuban government companies without satisfying normal immunity exceptions.
Okay, that's actually two questions crammed into one really dense sentence. Let me break this down.
Please do.
Question 1. When Congress passed the Helms-Burton Act in 1996 to let Americans sue anyone trafficking in Cuban stolen property, did they override the normal rules that protect foreign governments from lawsuits?
And question 2.
If they did override those rules, can American companies just waltz into federal court and sue Cuban government entities without jumping through the usual hoops that make suing foreign governments nearly impossible?
Why does this matter?
Because the usual hoops, called FSIA exceptions, require proving things like the foreign company's actions directly affect the United States. But Cuba and the U.S. haven't traded since 1960. How do you prove direct effects when there's a total embargo?
So it's like Congress saying, go ahead and sue Cuban traffickers, while keeping in place a law that makes suing Cuban traffickers practically impossible.
Exactly. Either Congress meant what they said, or they passed the world's most expensive piece of paper.
I get it. Now, back to Castro. He immediately grabs Exxon's oil refineries, terminals, and service stations.
What did those properties actually look like?
Massive industrial facilities. The U.S. Foreign Claims Settlement Commission valued Exxon's stolen property at $71.6 million in 1967. That's about $650 million today.
And Castro just gave these refineries to Cuban government companies?
Instantly. The defendants here, corporations Cimex and Union Cuba Petroleo, took over the facilities and started running them as state-owned enterprises.
So for 65 years, these Cuban government companies operated oil refineries and gas stations on stolen American property, making money the entire time. And here's where things get weird. Americans couldn't even sue until 2019.
Wait, what? Why 2019?
Congress passed the Helms-Burton Act in 1996, but every president from Clinton through Obama suspended the lawsuit provision. Trump activated it on May 2nd, 2019.
So Exxon files suit literally the first day they legally could?
Yep, the first day Title III lawsuits became possible. Exxon demands $280 million, their original loss plus interest and triple damages. The Cuban companies immediately moved to dismiss. They argue federal courts lack jurisdiction because they're wholly owned instrumentalities of a foreign state, so they get sovereign immunity.
And the court said?
District Court denies the motion, but the D.C. Circuit reverses, saying the Helms-Burton Act doesn't clearly override sovereign immunity protections. Cuban companies win, case dismissed.
So Exxon appeals to the Supreme Court.
Let's break down the legal battle. Exxon makes three main arguments, and they're surprisingly straightforward.
Exxon's first argument, plain text says we win.
What does the plain text say?
Title III creates liability for any person who traffics in Cuban stolen property. Then Congress defines person to include any agency or instrumentality of a foreign state.
So Congress explicitly said Cuban government entities can get sued?
That's Exxon's argument. They say this language mirrors what the Supreme Court found sufficient in a recent case called Kurtz, where the court said the Fair Credit Reporting Act abrogated federal government immunity.
Because the FCRA used similar any person language?
Exactly. Exxon argues, if that language works against the U.S. government, it works against Cuban government companies.
Exxon's second argument gets into what Congress actually wanted to accomplish, Congress's purpose.
Which was?
The Helms-Burton Act's conference report calls Title III a unique but proportionate remedy designed to deny the Cuban regime of Fidel Castro the capital generated by trafficking in stolen property.
So Congress specifically wanted to cut off Cuba's money pipeline?
Right. And Exxon makes a practical argument. If you force Title III plaintiffs to satisfy normal FSIA exceptions, you gut the law's central purpose.
How so?
Because of the embargo, the U.S. and Cuba haven't traded since 1960. FSIA exceptions require proving the foreign entity's conduct causes a direct effect in the United States. But if there's no trade, how do you prove direct effects?
Exxon gives a strong example. The court required them to prove either that Western Union terminals at their former gas stations increased net money outflows to Cuba, or that the Cuban company knows certain shelf products originated in America.
That sounds impossible to prove.
Exactly Exxon's point. They argue Congress created this remedy precisely because normal channels don't work against Cuba. Exxon's third argument is quite simply, no magic words required. This argument attacks the D.C. Circuit's reasoning directly. The appeals court said Congress must use unmistakably clear language to override foreign sovereign immunity, and Title III doesn't explicitly mention immunity or the FSIA.
So the court wanted Congress to say, we hereby override the Foreign Sovereign Immunities Act.
Basically. But Exxon says that's wrong. Supreme Court precedent establishes no magic words requirement for immunity abrogation.
What precedent?
The Kurtz line of cases. The court never required Congress to say immunity or sovereign immunity to effect abrogation. The court looks at what Congress actually did, not the specific words they used.
Now, the Cuban companies fire back with three arguments that are pretty clever. Their first argument distinguishes Kurtz. They say Kurtz doesn't apply here.
How?
They argue Kurtz involved absolute common law immunity, where recognizing immunity would completely negate the statutory cause of action. Here, the FSIA creates a restrictive immunity regime with enumerated exceptions.
Meaning?
Title III suits can proceed if they satisfy FSIA exceptions. Since some suits can go forward, immunity doesn't negate the cause of action entirely.
That's actually pretty sophisticated. They're saying, look, Congress didn't need to override immunity because plaintiffs can still sue us under existing exceptions.
Right. The Cuban companies argue that proves Congress intended both statutes to work together.
Their second argument invokes a fundamental principle of statutory interpretation.
Which principle?
Repeals by implication are disfavored. It's a cardinal rule that courts should harmonize statutes rather than finding that one repeals another.
So they argue Title III and the FSIA can work together?
Exactly. Title III creates the cause of action. FSIA provides the jurisdictional framework. Both operate together. No conflict, no need to choose. They also invoke another principle. Where a statute allows multiple plausible interpretations, we will not read it to strip immunity.
Their third argument gets technical but raises a real problem.
What problem?
If Title III overrides FSIA immunity, what gives federal courts subject matter jurisdiction over foreign instrumentalities?
I don't follow.
Section 1331 provides general federal question jurisdiction, but it contains no exception for suits against immune foreign entities. The FSIA's Section 1330 provides the only jurisdictional basis for suing foreign states and their instrumentalities. So if you eliminate FSIA immunity without eliminating FSIA jurisdiction, you create a legal black hole where nobody knows which law applies. The Cuban companies argue this proves Congress didn't intend to override the FSIA.
Here's where it gets interesting. The United States filed a brief supporting Exxon. That's huge because foreign sovereign immunity affects U.S. foreign policy directly. When the executive branch says, this matters to national interests, the court pays attention.
The United States makes three arguments. First, we have compelling foreign policy interests requiring Cuban government accountability. The U.S. argues that preventing the Cuban government from benefiting from wrongdoing serves paramount American foreign policy. They specifically mention their restoring a tough U.S.-Cuba policy.
So this isn't just about Exxon getting money back?
Not according to the United States. They argue that letting Cuban government entities evade accountability would be perverse and detrimental to United States foreign policy.
The United States' second argument supports Exxon's statutory interpretation. They point to multiple Libertad Act provisions that assume Cuban agencies and instrumentalities will face liability to final judgments. For example, the law says judgments against Cuban government entities will become unenforceable against a future democratic Cuban government.
That only makes sense if Congress expected such judgments to exist.
Exactly. The U.S. also notes that Congress found the international judicial system lacked fully effective remedies for wrongful confiscation and sought to endow Americans with a judicial remedy.
Their third argument addresses constitutional authority. The United States argues that foreign sovereign immunity remains a matter of grace and comity with decisions for the political branches.
Meaning Congress can revise the FSIA's balance?
Right. Earlier Congresses cannot bind later ones. The Libertad Act represents a tailored revision addressing the specific Cuban situation.
So Congress holds constitutional authority to override their own previous immunity grants?
That's the argument. The United States frames this as Congress exercising legitimate foreign affairs power.
Okay, now it's time for what this actually means. If Exxon wins, every American whose property Cuba confiscated can potentially sue Cuban government entities in federal court without satisfying nearly impossible FSIA exceptions.
How much money are we talking about?
The Foreign Claims Settlement Commission certified $1.9 billion in claims. With interest, that's about $9.2 billion today. But Title III allows treble damages. So we're potentially talking about $27 billion in liability. But if the Cuban companies win,
Title III becomes essentially worthless for claims against Cuban government entities. Private Cuban companies might still face liability, but the main traffickers, Cuban government entities running stolen refineries and hotels, escape accountability.
what about precedent effects?
Huge. This case affects how Congress can override sovereign immunity for any foreign policy purpose. If the court sides with the Cuban companies, Congress loses a major tool for addressing international misconduct. And if Exxon wins, other countries might worry about similar targeted immunity waivers. Looking ahead to oral arguments, what should we watch for?
First, expect intense questioning about the statutory interpretation. Did Congress really intend to override decades of sovereign immunity law without explicitly saying so?
What about the foreign policy angle?
The justices will probably press both sides on whether courts should defer to executive branch foreign policy judgments. The United States supporting Exxon carries real weight. Watch for questions about limiting principles. If Congress can override sovereign immunity for Cuba, can they do it for any country they dislike?
What about practical consequences?
The court might explore whether Title III actually works if plaintiffs must satisfy FSIA exceptions. If the statute becomes toothless, what did Congress really accomplish? Bottom line time, why does this case matter?
Because it defines the balance between congressional foreign policy tools and international legal principles that protect foreign governments from U.S. lawsuits, and it affects real people.
Right? Thousands of Americans whose families lost property to Castro's revolution have waited 65 years for justice. This case determines whether they finally get their day in court or face another legal dead end.
But the stakes go beyond Cuba. If Congress can selectively strip sovereign immunity when they really dislike a foreign government, that changes international law fundamentally. Other countries will notice immediately.
What happens if foreign governments stop trusting that American courts will respect immunity? International commerce becomes much more complicated. Foreign governments might stop investing in American businesses or participating in American markets.
But if the court sides with the Cuban companies, Congress will need to revise the Helms-Burton Act. Otherwise, victims of foreign government property theft face nearly insurmountable legal barriers.
That's Exxon Mobil versus Corporation Cimex. We'll definitely be following this one closely.
Oral arguments should be fascinating. This combines statutory interpretation, foreign policy, and fundamental questions about congressional power.
If you made it this far, share this episode with someone who thinks Supreme Court cases don't affect real life. Because I guarantee they care about whether American property rights mean anything internationally.
You can find us on Apple Podcasts, Spotify, YouTube, LinkedIn. Just search The High Court Report. Great show today. Talk to you soon.